Welcome everybody to today's webinar. We are talking about making a will in BC, and this is the best of edition. So as you likely know, this is Make a Will Week in British Columbia, and we are presenting this webinar for the 5th consecutive year in a row. And today's webinar, as the title suggests, is really the best of edition. We are focusing on some of the most common questions, popular questions that have come up over the years when it comes to making a will in the province. Now, my name is Paula Price. I am with the People's Law School. I will be your host and moderator today. And in just a minute, I will introduce our incredible guest speakers, Liliane Kazaku and Michael Scott. You may be asking, what are some of the best of topics that we'll be covering today? We are going to be talking about things like what is and is not covered in your will, what happens if you don't have a will, the difference between a notary and a lawyer, whether to use a will kit, how to choose an executor, when to make or update your will, and requirements for a valid will. Now, what you can expect today, we will be providing legal information, not legal advice. So if what you're looking for is the law as it applies to your unique set of circumstances, we would invite you to reach out to a lawyer, to a notary. You are welcome to contact our speakers. Their contact information is on the screen. We would like to acknowledge that we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we would invite British Columbians across the province and outside of the province to reflect on where it is that they are joining us from today. We would also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes it possible for us to provide these webinars for you. And finally, we would love to welcome, thank, and introduce our panelists today, Michael Scott and Liliane Kazaku. Michael is a lawyer with Clark Wilson in Vancouver, British Columbia, and he has an estate planning practice. His practice involves helping his clients with trusts, wills, estate and trust administration and accountings, powers of attorney, and representation agreements. So all the things that we're talking about here today. This is Michael's 5th consecutive year speaking at this particular webinar, and we are so thrilled to have him back. He's had such great feedback from guests at previous webinars, including comments like excellent presentation, panels explained in ways we can understand, and gave examples in scenarios. Thank you. So Michael, welcome back to the webinar. It's great to have you here.
Thanks, Paula. Thanks for having me back.
We are so glad to have you. And we are delighted to introduce Liliane Kazaku. Liliane is a notary. He's an award-winning notary public with Liliane Kazaku Notary Corporation in Langley, and his practice includes estate planning, where he helps clients, and I took this from his website, see where wills fit into the estate planning puzzle, great word choice, along with other planning documents. So things like powers of attorney, representation agreements, and advanced health directives. And in his practice, Liliane creates comprehensive estate and person plans to cover the basis for future events so that you can save money, taxes, and preserve your family relationships. So Liliane, thank you so much for joining us. We are delighted to welcome you to today's webinar.
Thanks for inviting, and I'm happy to be here too.
Wonderful. So our first question goes to Michael, and the question is this: what role does a will play in estate planning? And how do a power of attorney and representation agreement fit in?
Thanks, Paula. Well, a will in an estate plan can play a number of roles. So I don't know how thorough I can be in our time frame here, but very generally, a will, what it is intended for is a document to govern the succession of a person's assets that form part of their estate on death. And in addition to that, to appoint someone to take on the responsibility of dealing with the administration of the estate and the succession of those assets. In addition to that, a will, if for people that have minor children, they would often appoint a guardian to look after their minor children in a will. And there could be a number of other things as well, but very generally that's the purpose of it. Now that's different from a power of attorney and a representation agreement. So a will really is, if I die, then here's how I want things to go, and here's who I want to manage that for me. Whereas a power of attorney and a representation agreement, those are documents that only apply during lifetime. So those would be, if I'm living, then here's who I would want to handle my financial decision making and make financial decisions on my behalf. That's a power of attorney. So that's appointing an attorney under a power of attorney document. And then here's who I want to make healthcare and personal care decisions for me. And that's someone that you appoint as a representative under a representation agreement. Those documents are effective during lifetime, but then after death, those documents expire, and then the will kicks in.
Amazing. Thank you so much, Michael. And I think it's probably worth mentioning at this stage for anybody in particular who's joining this webinar and our People's Law School materials are new to them. There are previous webinars that talk about wills and estates, so you can search those webinars. There's also specific webinars that talk about powers of attorney and representation agreements. So there is further information through the website for anyone who's interested in taking a deeper dive. Thank you. Lillian, this next question is for you. And the question is this: what does a will typically cover? And do you need to list out every single one of your assets?
Yeah, very good questions. And the first part of the question is pretty simple. Most of the wills would have the same chapters or sections in the will. It starts with the personal information. Then it says, I revoke my previous wills, because you don't want to have two wills, valid, and you could destroy it, but also this section would just revoke it. Then you would appoint the executors or trustees, the guardians of the minor children, if you have any. And then after it says what to do, the debts, liability, taxes, and funeral wishes, the distribution of specific assets or residue of the estate. And then it's normally the second part of the will. Normally my clients have issues of, because it's very legalese type of written and needs some explanation. What those are the powers of the executor, what to do when they get into step in that role. And traditionally the funeral wishes are at the end. Normally it says cremation or burial, or if you're more creative, then you have other things now, like cryogenics wishes and all that fancy stuff that's coming up the pipe right now. The second part of the will of the question talks about the living, like, should we leave a single or do I need to list every single item or not? I would say, well, you can definitely insert any details that you want, but I would say, most of the time it's impractical, where it's counterproductive to your executor to administer the estate. We normally advise people to, if they have a valuable or very sentimental value assets that they really want to go to a specific person, definitely we can do that in the will before giving the residue of the estate to other people or to a list of people. But we normally recommend a letter of wishes, which is a morally binding document. It can be kept of the will, can be updated by the client at no extra cost, and I would advise people to do that.
Excellent. Thank you, Lillian. Michael, this is a common question that we hear often. What happens to your possessions if you die without a will? And what if you don't have much? Should you bother?
Okay. Well, if somebody dies without a will in BC, then it's called an intestacy, and basically what it means is that, well, for starters, you have nobody appointed to deal with the administration of your estate. And as a result, if there are assets that need to be addressed, or taxes or other liabilities that need to be addressed, then somebody has to apply to the court to be appointed as the administrator of the estate. And that's one. And number two is your estate. If there are assets there, then they would be distributed to your next of kin. So there's provision in our wills and estates legislation in BC, which sets out an order for beneficiaries if there's no will, or if there's an intestacy. And basically it's next of kin order. So it would be to spouse and kids. And then, but if you didn't have a spouse or kids, then it would be to your parents. And then it kind of goes grandparents, grandkids, aunts, uncles, cousins. So some kind of order like that. Now, if there isn't much, it's a good question, actually. And I do get this question, do I need to have a will if I don't have much in the way of assets? I'm not sure what Lillian has found in his practice, but for me, what I've seen happen a number of times over the years is somebody passes away and they leave 10 grand or 15 grand in a bank account, and that's it. But if there's no will, then as I mentioned earlier, nobody has any authority to handle the administration. There's no executor appointed. And so the banks, if there's no executor appointed, then the banks will require that the family or whoever the next of kin may be go through that court process to get someone appointed to deal with that small piece. That's a large burden for a small asset to have to go. That's probate. So it's going through the probate process in order to get somebody appointed as the administrator of the estate. Yeah, it's a strenuous process just to deal with a small account.
Mm-hmm.
If there is a will and somebody is appointed as executor and there's a small account, then the banks will often allow release of the funds to the executor without going through that court process, because it's just low risk for the banks. So even just having a really, really simple will in place is very helpful for the people that you're leaving behind to deal with your estate. So I would recommend doing it for really anybody should have it.
Yeah, the same here. You mentioned that it helps the executor open doors to when you speak to the bank or anybody else. So yeah, that's a really good comment. Thanks.
Excellent. Thank you, Michael and Lillian. And Michael, a couple of themes that came out there. One, a theme that we've seen in various iterations of this webinar, which is that planning up front saves you expense in the end. And the other thing I just wanted to mention is we've talked about executors a few times. We do have more questions about executors coming up. So for anyone who's wondering what that means, what that involves, we are going to be talking about that further. This next question is for both you, Lillian and Michael. Lillian, I'll start with you. What is the difference between a notary and a lawyer? And what can you expect if you hire a notary or a lawyer to write your will?
Oh, thank you. I'll start with the notaries because that's closer to my heart, I guess. So BC notaries have a more expanded scope of practice than notaries in most jurisdictions in North America. We're allowed to provide legal services in wills, real estate, areas of law. However, compared to lawyers, obviously BC notaries have a more limited practice. More specific, BC notaries cannot prepare complex testamentary trusts, including those that, for example, allow us to be held in trust more than when beneficiaries reaches 25 years of age, which is a little change that happened a few months ago. It was limited at 19 before. Therefore, unless your estate is more complex and you would require normally a lawyer, I would say that for a regular or simple estate, you could either hire a lawyer or notary public who could successfully help you with the estate plan. Regarding the fees, maybe notaries would have lower fees compared to lawyers traditionally. Sometimes we can offer flat fees if it's a simple estate. But otherwise, I would say what to expect is basically either a lawyer or notary public. You should expect 2 meetings, first one for discussion and gathering information, and the second one for signing documents after the drafts are approved. And by the way, despite some misinformation online, basically notaries can and must give legal advice when we prepare these documents. They are implied, legal advice is implied. So even if you're a notary or lawyer, you must give that legal advice besides preparing the will. And obviously, both lawyers and notaries can update the will and provide support during the lifetime of the clients.
Excellent. Thank you, Lillian. And Michael, is there anything that you'd like to add from the lawyer's perspective?
I think Lillian did a good job kind of laying out the answer on that. And I agree. Lillian, actually, that's news to me. I didn't know that the notary powers were expanded for trusts that run to age 25. Interesting that they came up with the age of 25 for that and not pushing out further, because I find a lot of people want to push it up further for their minor children, and it would be nice for notaries to have that ability to do it. But yeah, I think that's really, the one difference is the cost. Yeah, I expect that notaries would charge less than lawyers to do to do wills or estate planning. People would come to we do simple estate plans as well. But more people come to us when they have complex issues for their estate planning, whether it's difficult family dynamics or a lot of value in their estates, or complicated assets that need to be dealt with, or disabled beneficiaries, or anything like that. Then I think usually people would come speak with us, because they might be a little bit more comprehensive, and the notaries might have limitations on what they can do. But yeah, that's all I would really have to add to what Lillian said.
Beautiful. Thank you. And Michael, this next question is for you and Lillian. Michael, we'll start with you. And this is a question that comes up almost every year, which is, how much does it cost to make a will?
Who's going first, Lillian?
Not enough. Well, we charge, obviously. I'm assuming Michael wanted me to start because of obvious reasons that he just mentioned before, that we do charge less as notaries, although sometimes, as Michael said, both lawyers and notaries do simple wills, but I think so let's start with the price. I would say we charge about 500, around 500 or so for a will. And we provide some discounts if people want to do it together with the power of attorney or representation agreement as a package. It saves us some time, and why not to save people some money. However, I must mention that when people search around for the best price, they have to make sure they're comparing apples to apples. And I mean that the notary or lawyer who they're hiring, they have to inquire if that notary or lawyer will spend at least an hour with them, understanding their specific family and financial situation. So they may be able to prepare a custom-made estate plan, not just like a form that they normally use. And I think that's the biggest value. The value is not in just preparing the will, but more importantly, preparing in a way that will match the family needs first. And as a result, it could avoid family disputes. It will make sure that the will is part of a tax-efficient strategy. And not last, it's providing peace of mind and help family members not fight later on and have no disputes later on.
Thank you, Lillian. Michael, what would you like to add to the conversation?
Lillian, I think those are very reasonable pricings for doing wills. I think if we're doing wills on their own, it would probably be double that. So it would be 1,000, a couple thousand for a couple. So to do two, but almost always, it's very, very rare that people come to see us just to do the wills. I mean, almost always people are doing the full package, which is the wills alongside the powers of attorney and the representation agreements. And that ends up being around $3,000. So it's $3,000 plus taxes for the whole thing. So that's 6 documents. So a will, a power of attorney, and a rep agreement for each partner. So that's the cost. But I agree with what you said, Lillian. It's not, whenever we're preparing people's wills, it's not a matter of just filling in the blanks. It's a matter of having a meeting, talking about what your family background looks like, what kinds of assets you have, how you own them, considering what assets are going to flow through your estate, which ones are not going to go through your estate, in mapping out an overall plan for your will. Because I did see a question pop up just briefly on the chat about joint owning assets jointly. That's certainly something that comes up in every meeting that we have with clients. is, does it make sense to own assets jointly, or does it make, or does it not? And who do you appoint as designated beneficiary on your registered accounts? Those are the more simple, streamlined things, but there can, you know, be an endless number of things that pop up in these meetings to map out asset ownership so that it jives appropriately with the way that the wills are set up.
Excellent. Thank you so much. And what I'm hearing from you and my understanding based on this question having come up over the years is it really does depend on the complexity of what it is that you're seeking. That when you go in for a will, chances are you're also looking at the representation agreement and the power of attorney. And also that the cost, if we want to call it cost, is really an investment in saving taxes or at a minimum, but also looking at how to avoid conflict and cost down the road because the decisions have been made and clarity is there for those who are going to be administering, and dealing with the estate. So thank you both for your responses to that question. Next question is for Liliane. What factors should you consider when deciding whether to use a make-a-will kit?
Where should I start? So I know that the economy is that way, that we always want to save a little bit when we do anything, and that includes making a will. And lately there's so many online companies or that are very cheap, and or there are will kits that are free or almost free. While using a kit is maybe tempting to use, you know, like there are so many minefields, you know, let's put it that way, that you can accidentally trigger. For example, throughout my career, and I've done over 10,000 estate planning documents, you know, around that, I encountered only about 10 of them, like people when they bring their wills, and I've done this by myself or a company helped me. Honestly, like none of them, like after I reviewed their family estate and financial, and either they were blended families or anything like that, that was not a good plan in none of those situations. And I wish I can find one that was custom made, but mostly they're a form. There's a lot of good clauses in there, you know, fancy clauses of legalese, but not, you know, in some of them were actually disastrous too. You know, they're a blended family, and in a blended family, we could have a separate seminar or webinar on that, because it's very complex. But I would say if somebody still wants to save money and to do that, I would say consider the following factors. One is, will that let's say DIY kit or an online company, will they take in consideration the family situation? Let's say, as I said, disabled child or a blended family or any other family situation. Two, are the assets and liabilities being reviewed? Because, you know, besides the family situation, the financial situation is, we, for example, will look at the assets and liabilities. We'll look at the registered investments, non-registered investments, what goes through probate, what goes directly to the beneficiary. None of those are being considered normally in a DIY kit. Other one, you should, if you are assisted by a lawyer or notary public, you're getting the legal advice as well as a possible witness in court, because we are looking at incapacity. How about if the person in the state is sued by somebody who got less, that, you know, will variation, that, you know, it's a big litigation, you know, source in courts, right? So undue influence and incapacity maybe is the most important part, that you should hire a lawyer or notary public. But again, I get very passionate about this because I think people are tricked into, oh, you can spend just $25 and you can have a estate that is the same that as a lawyer or notary. You know, maybe you could go online and have templates for contracts and everything. I would not, though, save money on a will, but that's just me. I don't know. Maybe Michael has more to add, but that's my approach to this.
Thank you, Liliane. Michael, did you want to weigh in?
Sure. The only thing I would add, well, or I kind of agree. I mean, I haven't seen, it's pretty rare that you see a do-it-yourself will that works out, positively on the flip end. But very occasionally it works. It's just a high risk to take though. But the only time that it might, I might say to someone, hey, yeah, maybe it makes sense just to do it yourself is that scenario which we talked about earlier. If they really don't have any assets, but then it's still useful to have someone appointed as executor so that they can handle things, then, then maybe the do-it-yourself might be okay, but it would be ideal to have someone take a look at it that knows what a will should look like. And I agree with Lilian's comments about, at the end of the day, someone signing a will has to have mental capacity. There's a particular test of capacity they need to have in order to sign a will. And if they're doing it themselves and they're not getting any advice on it, then that question could come up as issue if depending on what the family background is and if there's potential dispute amongst the family and the dealings with the assets.
Excellent. Thank you so much, Michael. Michael, this next question is for you, and we've talked about this already a little bit, but what is an executor and what factors should you consider when choosing one?
Right. Yeah, we kind of talked about the executor role. I mean, ultimately, an executor is the person appointed under the will as executor, and their duty is to carry out the terms of the will. But the terms generally are to make sure that to collect up all the assets, pay out all the taxes and debts, and then distribute the estate pursuant to the beneficiaries that are laid out in the will. And then within that, that's a simple way to put it. But then within that, as executors, they have all kinds of responsibilities and duties at law in carrying out their job. So it's a fiduciary role, which means that they have to act in good faith and in the best interest of the estate and the beneficiaries. So they have to be careful with the way that they're carrying out their role. Now, who to choose? Certainly a question that comes up on every meeting, every estate planning meeting that we have, probably for Lilian too, of course, for Lilian too. The discussions that I usually have with clients on this is, it depends a little bit on the family situation. I mean, we're having a detailed chat around the family. And, if it's a situation where someone comes to us and they have kids and the kids all get along well, they're all local, and the estate is straightforward, then maybe it would make sense to have your kids act as executors, or have one or two of them act. If your kids don't get along well, then it's not a great program to name any of them really as executors, because it just leads to fights, and we deal with it on the administration side regularly, where it could either be a situation where we have co-executors, maybe two siblings acting where they don't get along and they can't work well together, and then it creates deadlocks within the estate, and usually they each get their own lawyers involved, and then which doubles the cost for the estate. It's not a good result. It could be more efficient to get an independent executor to act that's impartial, that can work with the beneficiaries to move the administration forward quickly. And now that independent executor could be a family friend, but it could also be a trust company. So that seems to be more. I know Lilian will have his own comments on this, but we're seeing more and more people hire trust companies to handle administrations. There's a cost to it. They're going to charge the estate. They'll have you sign a fee agreement. You don't have to pay them anything up front. They only get paid if they step in to act. But yeah, they get paid something, but they're professional, so this is what they do for a living. So the administration will go relatively smoothly, and they're going to check all the boxes that need to be checked through the administration process. And then your kids or whoever the beneficiaries are have no reason to squabble. So it just avoids fights and can avoid building wedges between family members. That would be now any executor can take a fee. I don't know if we get into this in any other questions, but so the other way to look at it is, yes, you got to pay a trust company a fee to do the job. But at the end of the day, even if you appointed any other executor, they're entitled to take a fee as well. So our law in BC allows an executor to claim a fee of up to 5%. And then it's a scale that goes down from there, depending on a number of factors throughout the administration process. So it's whether it's a trust company where they're taking a fee, or someone else acting as executor that may take a fee. It might not add cost necessarily. It's just getting a professional to do it rather than an individual. I should say one more thing, Paula, sorry, in choosing an executor. So I would avoid choosing people that are going to fight or people that don't mesh well with the beneficiaries. The other would be the residency piece. So it's ideal to have an executor that is resident in Canada. So they don't have to be in BC necessarily. These days, you can do a lot remotely, but certainly better to have someone in Canada. And if you don't have someone in Canada, then you could still appoint a non-resident as an executor, but maybe consider having a Canadian option as a backup, so that if non-resident, if this all comes to be, the non-resident has a channel to resign and allow a Canadian option to kick in if the advice that they're getting at the given time is that it's going to be too burdensome from a tax perspective or otherwise for the non-resident to handle it.
Super. Thank you so much, Michael. Lillian, this next question is for you, also on the topic of executors. What happens if you don't have an executor for your will, and should you hire a professional executor?
Yeah, maybe I'll start with what Michael said about the fees. We act as professional executors. We've been acting on several occasions, and I've seen actually when a family member, we were co-executor, and the family member charged more than us. So Michael is right. The law says up to 5%, and guess what? Some people charge 5% because it's allowed. It's just if it's reasonable or not, that could be decided if somebody challenges that. But absolutely, that's the law, and it's challenged based on a situation if people are unhappy. Towards the question is what happens if you don't have an executor? I think the question sometimes can be asked in that way, or how about if an executor is appointed but they refuse or can't act? Because that's most common what's happening, because most wills have executor appointed. The problem if they will and if they'll act or not. And I can say in my early career, I believe that as long as people appoint 2 executors, one primary and one alternate, should be good enough. But I worked with a law firm in the past, and then after 11 years in my notary business, I just realized that most people lately refuse to act, because when they realize how much work, liability, and other things involved, they just are reluctant to step into that role. And then we started, what's happening in that situation is normally court will appoint somebody, or public guardian and trustee will step into that role. Is that good or bad? Well, the good news is that we have an agency provincially who does that. The problem is that there could be backlog, because it's just the one agency that covers everybody who does not have a will and those who have a will but don't want to act. So I would say, appointing an alternate or 2 alternates will basically help that, and a professional executor will normally be the I call it a Goldilocks zone, because having no executor is really bad. Having somebody who charges too much, or it takes too long, so having a professional executor is in that category, that they would charge, and it will save some family disputes, because then you have a neutral person that I would say, if you want to choose somebody as a professional executor, think about what happens if you don't have an executor, like intestacy laws, right? So if you die without a will or without an executor, that will be applicable. Delays, complications, even increased costs, right? So if you hire a professional executor, you take advantage of their expertise. As I said, impartiality, because then they are neutral person. Normally, time and effort is, if you hire somebody who's done that before, it's much better. And then the stress of people, you just have to let the executor do their job, and normally it still takes about 2 years nowadays, with about a year, the whole probate and everything, plus clearing the clearance certificate of CRA that may take a little bit longer. So
Super.
I would say if you want to appoint somebody, appoint at least a couple alternates, and maybe appoint somebody, a professional, if you know somebody like ourselves, or a lawyer, or a trust company that you can negotiate the fees and sign an agreement that we normally sign, and we give them peace of mind that we won't charge 5%, even if our price may go up in the future. We will charge what we signed together.
Excellent. Thank you, Lillian. So we have a few more questions, and we'll go through these relatively quickly because we have a number of questions in the live queues that we're going to try to address as well. This next question is for you, Michael. What if I want to exclude one of my children from my will? How can I strengthen my will to better withstand a wills variation challenge?
Yeah, well, so just as a starting point on this, and I'll try to keep it as short and concise, so we can keep moving forward here. Wills variation, for anyone who doesn't know, is a provision we have in our law which says that your spouse and your biological and adopted children have certain rights to your estate, where if they feel they've been inadequately provided for through your will, then they have the right to apply to the court to seek to have the will amended or varied to build in a larger share for them. So it really is only it's only an impact on the assets that form part of the estate and are governed by your will. So one thing that we would do, it may not be a matter of strengthening the will itself. It may be more a matter of, if for people that don't want to provide to their children, or a child, or a spouse, or whoever it might be, that has these rights, maybe it's a matter of taking a look at the assets and seeing if there's another ownership arrangement that can flow assets outside of your estate, so that they will not be they won't be governed by your will. So any variation of the will is a moot point for those assets. You can do that through using joint tenancy for ownership, or using beneficial designations on registered accounts and life insurance, or settling trusts. So people that have significant will variation risk that are over 65 might look at settling a joint partner or an alter ego trust, and moving their assets out of their personal ownership and into that trust, so that it's no longer part of their estate, and then bypasses the will's variation risk. So there are lots of options like that, and everyone is going to be fact sensitive. So it just depends on people's specific situation, and there could be ways that you could adjust the will as well that would better protect. I mean, the very general test is to provide adequate support to your family members. So if you're doing that, then maybe the will's variation risk goes away a bit, and maybe a will be okay. But that might be a bit of an analysis with your professional advisor to see if that's going to be enough, or if it makes more sense to take those steps to move assets out of your estate.
Excellent. Thank you, Michael. And we have an entire webinar about contesting a will. So if anybody's really interested in that topic, they can go back to that webinar and learn in more depth about what to do in that situation. Thank you. Lillian, this next question is for you. What if you own property outside of Canada?
Oh, thank you. While our Canadian wills may cover assets located anywhere in the world, people should be aware that most countries in Europe and other parts of the world have very specific laws about transferring, especially the real estate assets. In any case, I would say if you do have assets in a different jurisdiction, the best advice I could give is engage and retain a lawyer or notary public in that jurisdiction as well, because we don't know the laws in every country. Although I come from another country, and I was trained as a lawyer in Moldova in Europe, I still don't know the laws in Moldova anymore. So I've been here for about 20 years. And that's the law I know. So if people ask me, I would defer to that country and maybe hire somebody there, so that will give them the right advice. However, if you do, that's the case, it's important to make sure that the will in that jurisdiction is made specifically and limited to only the assets located in that country. The biggest risk, make sure you advise the legal professional in that jurisdiction to make sure that they don't accidentally revoke your Canadian will, because as we said, every will normally starts with I revoke my previous will. So they accidentally may make a will in Guatemala, let's say, and they say I revoke my previous will. So their goal is achieved. However, our goal is revoked, right? So our will be revoked. So it's not a good idea. I would say, it's crucial to understand the laws, but, hire somebody who can let you know what you need to do. And but the key is regularly review and update your estate plan, because that's the time when things change. And if you think you have a will, but it's done 20 years ago, that may not be the good plan that you can have in your situations. So I would say.
Thank you, Lillian. Michael, this next question is, what if you don't have long to live?
If you don't have long to live, I suppose spend your money and enjoy your last days. Spend it all. And then you won't need to have, it won't be as important having the will. But if more seriously, if it does happen, and Lillian, I don't know if this happens for you, but we do occasionally, have situations where people have health issues, they're in the hospital and they don't have planning in place, and then we're doing it on a rush basis. So we're going to the hospital, we're meeting with these people, we're assessing their capacity to make sure that they're mentally capable to prepare the documents and getting their instructions, and then preparing documents and having them sign, wherever they are. So we're making the trips to go see these people. I kind of see it as our duty as a estate and trust practitioners to do that for people. It's not ideal, but it does happen. So you can still, if you don't have long to live, you can still get a plan in place. It's going to be rushed, and it might, and it's just the best you can do.
Excellent. Thank you so much, Michael. This next question is for you, Lillian. Do you need to get your will notarized, and does it need to be registered?
Okay, so first, I hear that a lot, so I have to take a step back, and just the word notarized is used so often that is misunderstood. So I need to clarify that. I see Michael is smiling too. So I want to make sure that these terms are not misunderstood. The verb to notarize sometimes used in the wrong context, and people believe that notarization is the magical word that implies that if a notary public signs on their document, it magically makes it legal, which is obviously not true. So there are some documents that we actually notarize, like, for example, statutory declaration or sworn affidavits. When people declare something to be true, we notarize. So that means it's an official witnessing of a document. However, sometimes people believe that, we can do separation agreements or other things. So I put that aside. We can do that. Notarization doesn't mean that. Secondly, we also need to understand that a will doesn't have to be notarized in that sense. So it becomes legal. Actually, if a will is properly executed and witnessed accordingly, it does not actually require to be even signed by a notary or lawyer. If you know what you're doing, let's say you're a paralegal for a good law firm like Michael's, and you're making your own will, maybe you could, know your things around and prepare it by yourself. Have two friends that are not getting any gifts in the will, because the gifts will be void, so make sure that's not the case. But yes, it doesn't have to be notarized or signed by a lawyer. The real value, as I said it before, is hiring a lawyer or notary public, not for notarizing the will, but the value is more in the legal advice and those things that we said before. Regarding the registration, I would say we always, recommend registering a will, especially that it includes just information like the names, date of birth, place of birth, and the location where the original will be stored. So by doing that, it will help your executor and the family to locate the will promptly and show the probate court that this is indeed the last will that was prepared by the deceased. So I would say yes for registration, no for notarization.
Excellent. Thank you so much, Lillian. And this next question is for you, Michael. What should you do with your will after it has been signed?
When we prepare wills for clients, almost always we keep them at our firm. So we have a safe, they go into our firm, we register, as Lillian had mentioned, we register the location of the wills through Vital Statistics BC. And that's it. They just go in there. We don't charge anything. It just goes into our safe. It's all coded in, and that's fine. But if people want to take their wills, they can. there are peak clients who will take their wills and put them in safety deposit boxes. I'm not a big fan of safety deposit boxes because we've had lots of challenges getting the wills out of the safety deposit boxes after the will maker has passed away. It's easier to get them from a lawyer or a notary because we know the system, whereas a bank representative might not. And some people keep them at their houses or give them to their executors, and that's okay too. But you really don't want to lose it. You need the original as part of the administration process. So that's why I think a lot of people just keep them with us, because then they know they're safe, and that works.
Beautiful. Thank you so much, Michael. And Lillian, we have one more question for you, and then returning to the questions that came in through the Q&A. And the question is, how often should you be updating your will?
Well, there's no magic number. I would say that every person should review their will about 3 to 5 years, and especially that this is normally the period of time that family and financial situation may change. And if you're unsure of your life events that change in the last 3 to 5 years, we normally provide a short consultation, about 15-30 minutes, when people either bring their wills or send them to us if they didn't prepare them with us, but or they can just send us a list of things that change in their lives, so we can tell them if they need to be updated. But I would say watch for the following: life changes, marriage, divorce, birth, adoption, death of a beneficiary, or change of assets. You won the lottery, or you lost a lot of money, so now the proportion of the estate distribution is not applicable anymore. Or changing in relationship, you separated, or normally we send an email to people that were at 5 years period, and we were surprised how many people came back and said, yes, this happened. So what I can say is that I get this question all the time. Do we have to change the will if the address change? So the answer is no. At least you don't need to update it if the address changed. The address normally is for identifying you where you live at that particular time. So, but any other big events in your life or financial situation, you may need to contact your lawyer or notary public.
Excellent. Thank you so much. So there are a number of questions here. Thank you, everybody, for these excellent questions. I'm going to go to the questions that are most related to making a will. I notice there's some that are more in the nature of what happens after. Lillian, I believe you were talking about the letter stating the wishes of the testator. And the question here is the letter stating the wishes of the testator a codicil, or can it be ignored by the court?
So 2 parts. First question about codicil. That's again another word that is being used a lot. People misunderstand it. I call it, the codicil is a tail of a will, right? And sometimes tail is not a good thing. I think a lot of litigation happen in court for codicils because it can be easily misunderstood. A codicil is just basically an update to a will saying, this chapter I'm canceling, I'm changing of this chapter. And let's say you misread the chapter, or how about whose insurance covers the mistake? The notary who did the first will, or the one that does the codicil. We provide, for example, a discounted price when people need a codicil, and we do a new will anyways. Then it's clear. You put the change. People still need it's just easier to read when it's a new will. So I would say not a codicil. I do codicils. I just don't recommend them. B, what was the second part of the court, right? So if this can go to court. So the letter of wishes is a letter of wishes. That's why it's called letter of wishes, because it's just a wish. It's a morally binding, but it gives, if you are the mom or dad and you gave that letter of wishes, if your kids are respectfully and everything, they will respect your last wish. But and maybe the court will take it in consideration because it was documented in a way. It was their wish. Maybe they're explaining why. Michael talked about will variation, why things were done in a certain way in the will. So I think the court may take it in consideration, but it is still a morally binding document.
Thank you so much, Lillian. Michael, this question follows up on a question that you had earlier. If people have joint accounts, no vehicles, rent, and have basic income and no other assets, is a will still required between spouses?
So yes, so let's take that. Let's take that scenario. So in that case, and let's assume that it's a true joint ownership. So it's gonna, if one of the two of them passed away, I'm assuming that for the question that if it's joint accounts, that we're talking about the spouses owning jointly. So if they if they have a joint account and that's really it. If one of them passed away, the account will go to the survivor of them. And yeah, that's right. It wouldn't go through the first person's estate. It would just go directly to the survivor. But then the survivor, if the survivor passed away, then it will form part of the survivor's estate. And if there's no will, then it's an intestacy and it will go to the survivor's next of kin. So if they don't have kids, then it would be to the survivor's parents or the survivor's siblings or whoever that might be. If the joint account is intended, so that there's a problem there, as whoever the survivor is, it will go to their family. It won't be split between both of their families if that's what is intended. But the other part of it, and so a will is necessary just to deal with the survivor's estate. And they won't know who that would be, so it would certainly be appropriate to have. We act for couples all the time, where everything is joint, and we always do wills for both of them, in order to deal with the assets in whoever is the last to die, but also to make sure that both sides of the family are going to be provided for, depending on what the people's intentions are. The second part, though, is that even with a joint account, there could be taxes and other obligations with CRA and other estate obligations. And if there's no will, then as we've talked about earlier, there's no executor appointed to do anything. So if there are any other things that need to be done, like, for example, claim any kind of benefits, CPP or other life insurance or whatever it might be, to sign a final income tax return, deal with various providers. So people have phone plans and credit cards and accounts. If there's no executor, then nobody has any authority to deal with any of that stuff. Mm-hmm. And so then the administration of the estate has hit a deadlock, or not a deadlock, but just a roadblock. And then somebody might need to apply to the court to be appointed. So certainly worthwhile to have wills in place in that scenario and in any scenario.
Just one thing, a short thing to add to that. So that's everything is correct what Michael said. But talking about joint accounts, we had a situation last month with not joint account, but also RRSP, which we know that it goes to the beneficiary, doesn't even have to go through the estate. So the people didn't prepare a will because they knew that the only thing they had is RRSP. However, the bank would not release those RRSP, although the wife was the beneficiary. They still wanted to see a will. And I don't know why. And it makes no sense for me too, but still, like, having a will, as Michael said, it opens door to the bank. You are the executor, you have the right, you show the will, open doors. There's no thing to say about that, and no excuses.
Yeah, Lillian, I've seen that too, from the banks, and the banks are wrong when they do that, and we've had to write letters to them before to get them to proceed without looking at the will. But usually there is a will, and we just send it to them because that's easier.
There is a will, there is a way.
Exactly.
Thank you both. Here's another question, and I'll put the question out, and Michael, Lillian, let me know, or you're welcome to respond. So whoever sees most suitable. Is there much difference between a will and setting up a trust besides the probate fee? Sorry, the probate fee. Thank you.
Can you repeat that one more time?
Yeah, and I think what they're getting at, there's a couple questions that go to this distinction of where you would have a will and where you would need a trust. I think that's really the driving question here. And they're making a note besides the probate fee that would presumably not apply using a trust, but you would be the lawyer. So
Lillian, you want me to do that?
Either way, like I could just say that, normally a trust would be recommended in a more wealthier families where there is a there is a disabled child that you want to put money aside, or a person who can't manage their estate money properly. So you make it first to separate it from the estate from that perspective. Yes, it could be for tax reasons as well. Although if you have, I would say, involve your accountant as well, because lately most of the trusts advantages that were used in the past, like they've been diminished, so it's not as useful as it has been in the past. And probate, it's 1.4%, 1.4%. Sometimes people get into, we didn't have these questions before about adding adult kids on title and all that stuff. When people try to save 1.4%, and get into 30 something or 40% in capital gains and other issues. So I just want to say that, and I'll leave it to Michael to get into more trust things if he wants to.
Yeah, I guess I would just add, I mean, we do that planning all the time for clients, but I agree with Lillian. It's the two primary reasons that people would carry out probate planning is, number one, they have a lot of value in their estate. And so they're looking to bypass the probate fees, which is that 1.4% tax. And so you can do that by taking assets and moving them out of your estate. And you could settle a trust and move the assets into a trust. And now they don't form part of your estate. They've bypassed probate in the event that you pass away. But that's an expensive plan to implement. So that could be, who knows? It depends on the details, but it certainly could be over 10 grand, maybe even 10 to 20. So it really needs to be worthwhile. If it's not worthwhile to take someone's estate, if they have $1 million in assets or $2 million in assets, where the probate fees are 15 to 30,000 to pay 10 to 20 to save 15 to 30, those aren't good numbers. It makes more sense when people have north of 5, 6 million, 10, 20 million even, then and up, because then the probate fees are into the hundreds of thousands, and to pay 10 to 20 in order to save hundreds of thousands makes sense. So that's good value. So that's one reason people would do it. The other would be if there are significant claims that are potential within the estate. Wills variation, we talked about that. There could be other types of claims as well. Then people might, even if they don't have a lot of value in their estate, if there's strong risk of claim, then maybe it would be worthwhile to set up a trust and move assets into the trust. But it's certainly an analysis, because you got to look at the types of assets, what assets might be easy to move into a trust, what assets might not be easy to move. There's a bit of an analysis to it, and I agree with Lillian. We usually, when we're doing that planning, we're engaging clients and accountants as well. It's a team effort amongst their financial advisors, their accountants, and their legal advisors.
And besides what Michael said about the big establishing fees, the federal government has put some reporting trust rules in place that every year you'll have to report, and you'll have to pay like a couple $1,000, or maybe depends on your accountant's fees to do those reports every year. So you remember that the trust is a separate entity and normally has reporting rules as well.
Super. Thank you both so much. Thank you, Michael. Thank you, Lillian. With that, I might just ask our guest speakers what maybe they would like to add. Anything that struck them as a theme from today's conversation, or anything that we did not get a chance to cover that they would like to highlight before we sign off for the day. And Lillian, I will begin with you if that's okay.
I would say the biggest, if you have to take just one takeaway today, I would say hire a professional for this work. Doesn't matter, a lawyer, a notary public, hire a professional. And secondly, do your due diligence when you hire them. Make sure that they will spend enough time and do a customized plan for you, and not just a simple will, 15 minutes over the phone type of thing.
Excellent. Thank you, Lillian. And thank you so much for joining us today and sharing your insights and information about this incredible topic. Thank you. Michael, any last words before we part ways for today?
I really second what Lillian said. I mean, I think it's these days, it's really important to get professional advice when you're setting up your estate planning. It's just, it's unfortunate, but it's an area that's just becoming more and more complex, and really requires a lot of professional attention from someone that specializes in the area.
Thank you both. Thank you to the People's Law School team. And thank you, everybody who joined us here today. It's been a pleasure having you. And we will give you information about our next upcoming webinar soon and hope to see you there as well. So thank you, everybody. Happy Make a Will Week. And we'll look forward to reconnecting again soon. Bye for now.